Thank you for coming to our panel. We're glad you joined us. We are here to talk about mock arbitrations. Those of you in the audience who have had experience with jury trials may have participated in mock trials, where the decision makers tend to be lay people with no experience in the legal area or in the substantive issues involved in any given case. But what about mock arbitrations, where the decision maker is decidedly more sophisticated and certainly knowledgeable about the law and frequently about the subject matter involved? What value would a mock arbitration bring in those situations? That is what we are here to talk about today. So with us today are Judge Elizabeth Ray. Judge Ray has been involved in one aspect or another of civil trial law for over 40 years, first as a litigator for 14 years, followed by a career as an elected civil trial judge for 19 years. She's tried over 500 cases to a jury verdict and more than 100 cases non-jury. She's performed several hundred mediations and several hundred arbitrations. To my immediate left is Dr. Donald Vinson. Dr. Vinson is a leading authority on the application of behavioral sciences to the resolution of legal disputes. He's an expert in human behavior who has spent the last 40 years working with hundreds of attorneys in high-profile legal cases. His training in the social sciences includes an MS in marketing research, an MA in sociology, and a PhD with emphasis on the psychology of human values, attitudes, and decision-making. He's the chairman of Vinson and Company and the author of the excellent book, may I hold this up? Arbitration, the Art and Science of Persuasion, which is excerpted in the materials for this panel discussion. To Judge Ray's left is Sasha Dimitrov. He is the national practice leader of Baker Hostetler's International Commercial Arbitration Team. He represents clients in commercial matters with an emphasis on energy disputes, breach of contract and commercial fraud, oil and gas litigation, financial matters, and internal investigations. He has successfully represented U.S. and international companies in courts and arbitral tribunals around the world. He's won multi-million-dollar awards prosecuting his clients' claims and has successfully defended Fortune 100 companies in multi-plaintiff lawsuits alleging up to $300 million in damages. He's currently listed as a neutral for both the ICDR, as well as its complex commercial arbitration panels. Finally, we have Alberto Ravel, who is a managing counsel in the commercial and environmental litigation section of ConocoPhillips and has more than 2 decades of experience handling international disputes concerning both commercial and investment matters. Before joining ConocoPhillips in 2012, Alberto was the senior associate at King & Spalding's Houston office and a member of the firm's International Arbitration Practice Group. So now that we've met the panel, I would like to start by getting to know the audience just a little bit. Apologize for starting with audience participation. Thank you to those of you who completed our poll prior to this panel discussion. The poll was about your experience with conducting mock arbitrations. But I want to start with just understanding from our audience whether or not you have actually participated in a mock arbitration. By a show of hands, how many of you would say you are familiar with the process of mock arbitrations? Quite a few. And on the other side, how many of you would say you're not very familiar with how they work, with the nuts and bolts of a mock arbitration? Okay. So I think that might be a good place to start. Dawn, if I could turn to you, would you kindly share with our audience the process of conducting a mock arbitration, what a typical methodology would look like?
You know, when I think about mock arbitrations, the first thing I tend to think about is what is your objective? Why are you doing it in the first place? Is it to be predictive? Are you trying to predict what is a likely outcome of the case in a real arbitration? Or do you have other objectives in mind? And if it's the first objective, that is predictability, one has to be very, very careful. And I'll come back to that in a little bit, but you have to be very careful with methodology. We have gotten very good in the social sciences at predicting human behavior in a variety of different environments. We're particularly good at it at jury research these days. We've had a lot of experience over the last 40 years. And if you conduct these sessions correctly in terms of validity and reliability, and those are the two key terms to keep in mind always, are the results you're obtaining valid? That means if you're looking for specific areas of vulnerability in your case or specific opportunities, are you measuring the right things? That's validity. The second one is reliability. If you do it a second and third time, will you get the same answers? It is critical that when you do studies with people and you really want to depend upon the analysis that you obtain, are you comfortable with validity and reliability? The second thing is we have, as social science people, gotten very good at predictability in this country. For an example, consumer product surveys. The big consumer product companies are very good at that. And up until recently, political polling has been very good. Why did the Republicans take such a beating with the red wave that didn't exist? The reason was their pollsters got it all wrong. They had problems with validity. And so that is kind of an overarching methodological consideration that I would encourage anyone who's thinking about mock arbitrations to ask the two questions. Are the results reliable? Are they valid? Why are you doing it? And I'll come back later to the second, perhaps, best reason for doing mock arbitrations.
Thank you. May I turn to Judge Ray? Let's, if you would share with us some of the considerations you might undertake when deciding whether or not to participate as a mock arbitrator.
Well, that's a tricky question. If you participate as a mock arbitrator, then you do not participate as an arbitrator, and obviously for conflict reasons. And so you have to be careful. I think as a practicing arbitrator, I'm careful which of those assignments you accept and which ones you pass by on the theory that, well, I may get chosen as the arbitrator in that case, and I don't want to be conflicted out from that. So, and it's always a balancing act, because when you get invited to be on a mock arbitration panel, you don't have the obligations that you have, of course, when you're actually the arbitrator in the case, so it's easier, and you don't have to work as hard. But at the same time, you lose out on the opportunity to go forward on the panel, and that is, I generally will pass that by in hopes that I get selected for the panel.
So before we shift to Alberto and Sasha on the considerations about when it might be the right time to conduct a mock arbitration in any given case, Don, could you tell us a little bit more about the specific methodology? How do you go about selecting the mock arbitrators, and what considerations? We heard a discussion earlier in the panel, in the last panel, about sort of bespoke arbitration methodologies. So what kind of goes into how you set up a mock arbitration when you're dealing with your clients?
Again, back to my original comment, what is your objective? If your objective is to predict, then what you want to do is try to select mock arbitrators that you think, in one way or another, capture some of the major characteristics of your actual panel, or the panel you're likely to have, in terms of their cultural background, their legal background, their experience, where they're from in the country, where they went to law school, what kind of practice did they have. And then, in addition, if your other objective is one of, which I think is one of the more valuable aspects of mock arbitration, is the practice session, giving your counsel and your clients the opportunity to just test out the, if you will, production value of what you ultimately intend to present to an actual arbitration panel, and let people practice. I think that's one of the more valuable aspects of it. So I think the two things you think about: one, what are your objectives? And number two, if it's to try to predict, you have to be very careful in the selection of your panel and what kinds of information you give them, and make sure that you're being as complete as possible within the confines of the time and constraints you have with budget and other realities.
So thank you. So let's talk more about what goes into the decision to whether or not to conduct a mock trial in the a mock arbitration in the first instance. If I could shift to Alberto, and roughly, if you could say, what percentage of your cases do you opt to conduct a mock arbitration, and how do you make the decision? What factors do you consider on whether to proceed?
So first of all, I'm going to borrow Jean's disclaimer and
so
say that
sorry.
I'm
Yes.
speaking personally and not on behalf of the company. With that said, I think all of our cases go through some form of mock or rehearsal. And now there's a big range there. There's we'll do a run-through before the hearing, or we'll do what I will describe as a full-blown mock. 3 arbitrators. We have a U-shape table in a conference room, witnesses, experts, IT, screens, hearing bundles, the works. And that end of the range, I would say, is usually reserved for high stakes conflicts, high profile, and disputes where the amounts at issue are significant enough to justify the cost of a mock hearing of that proportion. With that said, there are very small cases that are important for us from a number of reasons where we also consider having a mock, perhaps in a reduced form, just to sort of us to test the arguments and going to the goals of a mock and our objectives. For me as a client, I have both internal goals and external goals. Let's start with the easy ones. The external goal is making sure that I can present the best case for the company. But in terms of internal goals, I found it very helpful for us to not only assess whether we're ready or not for the hearing or for the case, but also it's also important for the witnesses to give them a first experience of, a lot of them have never testified, and in arbitration especially. So it's a good experience for them to, experience a hearing room, mock questions, and being in front of mock decision makers. It is also a very good experience for our internal clients. We spend a lot of time trying to work with our clients and explain the hurdles for each case. We always have good cases, but there's certain instances where we have issues and we have bad documents and stuff like that. And those hearings are very helpful to show those internal clients those bad documents. Hearing from a red team, when we have a red team presenting the argument for the other side, listening to the red team and thinking, oh, geez, we do have an issue with that bad document. So it's also helpful to manage internal expectations, and I would say even for potential settlement. You finish a mock and you say, well, maybe this is a good candidate for some sort of early resolution, settlement, or maybe mediation.
Alberto, may I ask a follow-up question on that? It sounds like there's an opportunity, as Don said, for predictability, but also for improvement if we're giving an opportunity to do a test run. At what point in the process do you think is the right time to conduct a mock arbitration?
We typically do it after briefing is completed. So we have the benefit of the written submissions from both sides, but before the hearing, with enough time to make changes if you need to. Don was saying, again, going back to the objectives, I don't think we go into a mock arbitration to hear a mock arbitrator say win or lose. It's more about what can we improve, the feedback, and that I think is an important component of any mock arbitration, is building enough time to get real-time feedback from your mock arbitrator, and using that feedback then to improve your case, improve your strategy, make changes to the team. Maybe you say, well, maybe that person that had this role would be better in this other role, or I need to switch counsel. You want to give yourself enough time before the hearing to make those changes.
And when you say feedback, wanting to incorporate the feedback, what is the most valuable feedback you find you've received from conducting these?
So, in each mock arbitration that we have, we build enough time for feedback. And so what we do is we do feedback on the individual cross-examinations, but also feedback on opening or closings if we have them. And I would say for me, the most important thing is to get honest feedback. That's why I usually try to go with a mock arbitrator that is outside the organization, and by that I mean not only outside the company, but also outside the firm or outside counsel team that's representing us. I've had a lot of firms say, why don't we have my partner be the mock arbitrator? And that's probably okay in some matters, but you want that external factor. You want that honest, non-biased feedback. That's what I find most helpful. And I would even have follow-up discussions with the mock arbitrator post the mock hearing to get more of that honest feedback.
Thank you. And Sasha, as a practitioner, what factors do you consider in deciding whether or not to proceed with a mock arbitration?
A lot of the same factors that Alberto mentioned. The question really becomes, when you're preparing for a case, you see the other side's memorials, you see their positions, but there's a tendency to drink your own Kool-Aid. And client expectations are also based on the feedback they're getting from their lawyers. It's good to get an outside perspective. It's good to road test your theories. It's good to road test your witnesses. And it's good to get feedback on what works, what sticks, what doesn't stick. Do you need to pivot? Are the lawyers doing a good job? Do we need to switch the roles of who's doing what? It's a really valuable tool, and I just echo Alberto's views. I think you do it after the memorials are done, after you finish the briefing and before the final hearing, giving yourself enough time to make those changes as needed.
Do you find that you are more often in alignment with your clients on whether to conduct a mock?
As clients are becoming more sophisticated, and by that I mean a user of our legal services, if it's a one-off, it's a very different experience than you have a client that is experienced in doing arbitrations on a pretty regular basis. Those that are more sophisticated tend to be a little more open to it. On the other hand, those that are a one-off, but it's a bet the company case, they want to make sure that you're taking all the precautions. Issue becomes one of money. Issue becomes one of resources and time. But I think if it can be done, it's a wonderful tool.
So certainly there are there's substantive feedback that is useful to receive. Dawn, you mentioned earlier about, sorry, you're taking a drink, about the application of social science to these mock arbitrations. Do you find that there's an opportunity to improve credibility for advocates, for witnesses, through the use of these mock arbitrations?
Yeah, absolutely. And I think that the ConocoPhillips example is a very, very good one in terms of just determining in advance how your witnesses are going to perform, how your demonstrative evidence is going to be perceived. Are your graphics understandable, as an example? Just all of those details that go into persuading another human being to the position that you're advocating. It's a basic tenet of advocacy, of course. So, yes, I think that your approach is an excellent one.
Thank you.
Judge Ray, in your experience as a decision maker, what kind of feedback would you most want to offer to people who are participating in the mocks?
I think we have to really think about when to use these mocks and when we shouldn't. I think we should use them. It's a good tool for the bigger cases. I think I don't know that you have to do a formal mock arbitration in order to do a lot of what these guys are talking about. I think, trial lawyers should be doing that anyway, and I suspect they are doing that anyway. They're already practicing their cross exams. They're practicing, and I'm hoping that they look at, maybe this person is not the right person to cross that person. I'm hoping that they sophisticated enough to know to do that. You don't have to have a formal mock arbitration to do that. And, you know, old trial judge, you know, I can tell within 5 minutes if you're prepared or not. I can tell within 5 minutes if you know your documents or not, if you know your case or not. You know, I've had that, and I know y'all know what I'm talking about. I've had that moment where the lawyer stands up and totally freezes because they're like, and that's because they don't know their case. And they're worried that they're going to present something to me and I'm going to go, no, which, you know, I tend to do, unfortunate expressive face. So I think that a lot of what these guys are talking about on these mock arbitrations is preparation and over-preparing and knowing your case and knowing what the cross-exam is going to be like and knowing what the witnesses say. But when you get to those really large cases where there's a lot of moving parts or a lot of arbitration days, you know, a couple of weeks, a month, however long it's going to be, I think you have to go through the mock arbitration process. I am curious, and I'd like to ask my panelists, how do you pick the arbitrator? And the reason I ask that is because, you know, having done this now a little while, I think it'd be real easy to say, you know, I think I'll go get, you know, some age white arbitrator lady from Houston, and she ought to do. And I just want to tell you, that's not how it works, you know, because there's a whole lot of people that you might think are going to rule the way that I rule, or you're going to think, well, that's probably about what she's going to do. And that's not predictive. And that kind of goes to Don's point on, you know, how do you predict what the arbitrator is going to do? I think all the practice stuff is great. I think what Alberto said is brilliant because, you know, sometimes we forget that there are back clients that have to be persuaded or, you know, or you show them that email, you know, that one they didn't tell you about, that one. You show them that email and say, this is how this is going to play. And gosh, all of a sudden settlement just pops right up. It's awesome. So I think there's a lot of moving parts here, and there's a lot of right times to use it, and maybe not so right times to use it. These guys who have done this more than I have, I think can lend information to that.
Yeah.
So, at least from my standpoint, what we try to do is what Don said, sort of who is the arbitrator, and how we can replicate that person. So we look at, you know, when they went to school, where they're from, training. I also like to get people that know the arbitrator, that has sat with that arbitrator, because that has tremendous insight into the thinking process, into the decision-making process. But at the same time, that's worthless if you don't have someone that can provide the feedback. So we've done it in a case where we had, you know, someone very close, like on paper, she read, in that case, like our arbitrator. But the feedback was not great. It was very limited. And so that was one case where we said, oh, we could have gone with someone that we knew better, just to make sure that we're receiving the right amount of feedback. But again, the general rule is try to replicate the arbitrator, sort of, I think somebody said yesterday, sort of an avatar of the arbitrator. And then that second component, and someone that can provide feedback.
Yeah, I agree with that. What's interesting about international arbitration is you're dealing with a different set of rules, and particularly in England, where there's no conflict to have your advocates and your arbitrator from the same chambers. What's interesting about that is you've got, pick the chambers, you've got two lawyers, two barristers who've worked together, and sometimes work together on a case and know each other very, very well. So what we try to do is find someone who knows this arbitrator, knows how they typically rule, knows how they think, and particularly as an advocate, and can replicate the demographic. And by demographic, I don't mean this is a 60-year-old white male in England, but a person that has practiced commercial litigation, commercial arbitration in the oil and gas field, who's had these issues arise and tends to be more conservative or more liberal. How have they dealt with this issue in the past, and what kind of impact is this argument going to make? How are they going to react to this testimony? We have an expert who has kind of an unusual view. How will they react to that? And the feedback becomes critical. But I think in international arbitration, you have more tools at your disposal.
To Alberto's point earlier, I have to grin when I say this, that mock arbitrations are a great ego leveler in many respects. for lawyers as well as for expert witnesses and for the client internally.
Good point.
That's a great point. I'm going to use that line.
You know, if I can add on to something that Alberto said earlier, one of the things that we found in international arbitrations is that you have a red team and a blue team, who the red team takes the other side. But the red team knows your case, and the red team knows your weaknesses, and the red team can do a really, really good job and beat you, and it freaks the client out. So one of the things that's really useful, and I'm borrowing a story from a friend, but one of the things this is really useful for is to not only teach your team, but also to manage your client expectations, because your client thinks you've got a wonderful case, you've got wonderful lawyers, and of course you're going to win. But the effect of that email, the effect of that argument is sobering, and it may not lead to settlement, because I think most of international arbitrations tend to go the whole way, but it will lead you to make pivots that can be critical to your case.
Just funny you say that about the red team. We feel that it's as equally important as to picking the arbitrator as picking the red team. And we usually, you can go external. And then the problem you have there is that you have another firm come in and try to show off a little bit, try to get the case. What we found most helpful is to have either the junior partner or the senior associate do the red team argument. And that's where you see that they know the case better than everyone else, including the senior partner at the firm. So it is a great ego equalizer.
You know, I want to speak just a minute about the arbitrator, because I think that's so interesting. You know, every panel that I'm on, and I tend to be more on panels than on singles, but every panel that I'm on, you know, it really does make a difference who the other co-arbitrators are. It makes a huge difference who the chair is in terms of how things go forward and the speed of things, and you know. But there are, I would say it's about half-half, where the arbitrators have sincere disagreements about what they think the evidence showed, and you know, how they think things are going and that sort of thing. It's about half-half. It's not. I think that sometimes people think, gosh, you know, arbitrators are just all buddies and they get back in there and they just all agree, it's all great. It's not like that. I think there's sincere disagreement, and I think that's healthy. I frankly think that's a healthy thing to be doing, to kind of mush forward. I think an unhealthy thing, and I've been on a couple of panels lately that I don't know how y'all feel about this, but they keep asking for additional briefing. And, you know, in my mind, that's not what arbitration's about. It is not litigation. I keep trying to tell that to lawyers, and they don't get it. But I keep trying to say to them, this is supposed to be faster, cheaper, more efficient. You know, I love hearing about how all this happens international, where they don't do depositions and all that sort of thing. And I tell people that in domestic arbitrations, they think I'm crazy, you know. So I think that's part of what I think can be done with these mock arbitrations is to help kind of contain the cost there. But I think also, I think it's interesting to keep in mind that the arbitrators, you know, I don't even know what my reputation is out there, but I do know when I get on panels with people who do read and do study and do take the time, and when I get on panels with people who don't, and then my arbitration role changes based on what's going on with the other arbitrators.
Sasha, we've talked around sort of the different considerations for international arbitrations. Would you tell us some of your experiences and how that might differ?
You know, one of the biggest differences, I think, with international arbitration and domestic arbitration is the way you present your evidence. With domestic arbitrations, as we all know, you put on direct evidence, you put the witness on the stand, and you teach, traditionally the judge, here the arbitrators, your case. In international arbitration, as the prior panel discussed, you're putting on all your factual and your legal evidence in the form of memorials, meaning that you're not going to put a witness on the stand. What you're instead going to do is write a witness statement of what that witness testimony is going to be. And by the time you get to the final hearing, the arbitrators have literally read everything about your case. They know what the witnesses are going to say, they know your legal arguments, they know the documents. So when the case starts, if I'm the claimant, I stand up and I present Ms. Jane Doe. I'd like to call Ms. Jane Doe. Ms. Doe, is this your witness statement? Yes. Do you have any changes? No. Is this your signature? Yes. I pass the witness. And the case starts with cross-examination. What's interesting about that in this format is how do you do a mock arbitration when you don't have a jury? You know, you basically have an arbitrator you're trying to duplicate. And what's even more interesting is in different jurisdictions, different ethical rules apply. So for example, under the English system, you're not allowed to prepare a witness to testify. You know, for me, it's malpractice not to prepare a witness. For them, it's malpractice to prepare a witness. And I want to talk a little bit about that dynamic and how it gets resolved. I think what's a good way to do it is what can they do? How much can they do it? And what can't they do? And in English arbitration, and this is written from one of their journals, mock questioning is expressly permitted to give a witness greater familiarity and confidence in the process of giving evidence and giving oral evidence, provided the exercise is not based on facts, and there are no similar or same facts as those in a current or impending trial. So you can put a witness on to get them comfortable about testifying, but you can't talk about the case. Now, how much is this allowed? The Bar Council, which regulates English barristers, says, quote, suggesting an answer to a witness, like I suppose what you're trying to say, or conveying an answer is wrong or implausible would and plainly ought to breach any professional code. So the next question is, what does their professional code say? The English Professional Code of Responsibility says, a barrister must not rehearse, practice, or coach a witness in relation to his evidence. So my question is, then how do you write your witness statements? The answer is the witness presumably writes it, and you ask questions and show them documents they may see. But the issue becomes you've got two competing sets of professional conduct, rules of professional conduct. As I said, for them, it's malpractice to do it. For me, it's malpractice not to do it. So I called Lucy Greenwood, who's a wonderful arbitrator, at Judge Ray's suggestion. And she has a unique position in that she's now an arbitrator, but she was an English qualified lawyer working at a U.S. firm. And I asked, how did you do it? How did you do it at the time? And her answer is, you know, I wouldn't participate in the witness preparation. I would simply work on the witness statements, but I'd walk away and I would let my partners, my U.S. partners, do the actual witness prep. And I've had the exact same experience where the English barrister, knowing he can't do it, says, I'll leave the room, you guys do what you need to do, knowing I can. So the question becomes, do you need one common set of ethics for international arbitration? And I asked Lucy the same question. I said, as an arbitrator, how do you feel when you've got English counsel? And I've got a case right now. I'm the only American lawyer in an English arbitration under the London Court of International Arbitration rules. And it's interesting how that dynamic works. And I said, as an arbitrator, are you offended as an English arbitrator when someone prepares the witness? She said, no. So how do you reconcile the two positions? She said, honestly, I think it's an over-exaggerated difference. I think it becomes one of lawyer competence. I think it's okay to talk to witnesses. The concern is that you don't teach the witness you don't over-rehearse them because then they're not credible, and you don't tell them to lie. I said, well, we don't tell them to lie. She says, you don't tell them to lie, but somebody will tell the witness what the answer should be if it's not accurate. I said, that's not my experience. She said, you haven't seen the people we've seen. I think the dynamic here is it's all right to get the witness comfortable. I think you use your team in the way they can professionally act under their rules of conduct. And in international arbitration, the rules of evidence are much more relaxed. I think the way you prepare the witness is to make sure that they're answering truthfully, that they're giving their own answer, that you're not putting words in their mouth. But on the other hand, if you're a good lawyer, you explain to the witness exactly how their testimony is going to be used, what the purpose of the testimony is, and then you ask them for their truthful testimony. And you don't try to change it or bend it because they're going to get destroyed on cross-examination.
Okay. You were nodding along, Alberto. Did you have anything to add to that?
It's just funny hearing you say that, Sasha. The one thing I tell all my witnesses, if they ask you about prep, if they ask you about anything, what are you going to say? And they say, you told me to tell the truth. That's exactly what you need to say. Just on specifically to our mock consideration, we had a recent example where we were dealing with a jurisdiction where the ethical rules are even stricter than in the UK, where the lawyers there cannot do any sort of mock. And this was a mock with US, UK, and counsel from that jurisdiction. And what they did is they chose not to participate in the mock crosses. So they were there for the opening, for the feedback from the arbitrator, the mock arbitrator, but not for the actual mock. So I've seen that. It is a limitation in some instances.
That's been our experience also. The lawyers take roll only in the parts that they are comfortable under their rules of professional conduct.
Well, and if I could, just one quick comment.
Please.
You know, one of the things that I do in my arbitrations, and I do it in almost every arbitration, is I ask questions. And your witnesses aren't prepared for that. You know, they certainly aren't prepared for, and particularly if I think that one has been, shall I say, overcoached. You know, I start digging down with them. Well, why do you say that? Where did that come from? Do you have a document that supports that? You know, blah, blah, blah. I'm not trying to intimidate them. I'm trying to get to the bottom of what are you saying to me and why are you saying it? Are you qualified to say it? Do you know what you're talking about? Or has somebody just coached you along? And so I can get fairly, this will surprise you, fairly aggressive with my questioning because I'm really just trying to get to the bottom of it. And that cuts through all the coaching.
So I want to turn back to the audience. We asked earlier whether you had a familiarity with these mock arbitrations. I want to ask you a question about your actual participation. So the question is just whether you've participated, but there's 3 answer choices. So the first is yes, you have participated. The second is no, but you would consider it. And the third answer choice would be no, and you would not consider it. So give me a show of hands if yes, you have participated. Yes, okay. And what if you haven't, but you are considering it? And so, I open this up to questions from the audience on whether if you are considering it, what factors are you considering? Is there any feedback you'd like to get from our panelists on some of the factors that are relevant to you? If not, I'm just going to ask these panelists for any examples of impact. Do we have one? Yes, right here.
Again, are you not destroying the credibility of the witnesses for the international arbitration if you do mock questioning? The issue is, I think most of you, or some of you, may be familiar with the research by Professor Reid from Exeter University in England on the credibility of witnesses, and usually my experience is most arbitrators take the witness against the party who has nominated them because they are not convinced on the other thing.
May I address that?
Sure, please.
You know, there's a presumption in there that when we're preparing a witness to testify, we're preparing them to say something that's not true. And that's absolutely a false premise. The very first thing we do is tell the truth. What we try to understand is what the truth is and what their testimony is, but there's different ways to present evidence. And I'll give you a war story that I think really defines this. This was in a domestic trial, but I think it also applies in this context. We had a witness who was a disgruntled, fired employee, and I presented him, and the issue was there was a failed piece of oil field equipment, and he was asked whether, he was shown a document, and there were deltas above different parts of this equipment. And he says, doesn't this show a change in the design after the accident? He said, yes. And my client's sitting next to me. We take a break, and the client says, I think that's just a part number. And the guy says, oh, yeah, that is a part number. I said, do me a favor, and when you go in, would you just please correct your testimony? And we go back on the stand and say, excuse me, I have to correct, the lawyer said I have to change my testimony. So that's what you avoid by preparing the witness. You know, what you try to do is present their testimony, their truthful testimony, in a way that's time effective, in a way that's truthful, and in a way that fits the context of what their role is. You never, ever tell them to lie or bend the truth, ever.
I agree with that, and I think the exercise is, at least from my standpoint, is more about giving the witness the experience of in this case, a mock cross. So, it's not a conversation. It's something different from what they're used to. We've got engineers and drilling engineers, and these are not people that do this for a living, so they've never seen that other than on TV. So giving them the experience, they find it very helpful. Like Sasha would never say, we never try to bend their testimony or the truth. And what I found, and we've learned this sort of the hard way, is that whatever you get on that first interview with the witness, when you're, even before filing anything, is what you're going to get on the stand. No matter how many mocks you do, no matter how, if you want to coach him or not, it doesn't matter. Whatever you get on day one, you're going to get on the stand at the hearing.
What are some other potential controversial issues that you have faced in preparing for mock arbitrations? Or are there any limitations or drawbacks that you see in the current practice? John? Go ahead.
Yeah, the people I speak with, particularly in London, are really concerned, hyper-concerned with the whole notion of conflicts. And Sasha, he alluded to that earlier and in fact spoke something about it, but maybe you could go into a little more detail about what you see as the difference between conflicts in the British system or internationally and the American system.
You know, I'm happy to talk about that. It's a unique system for barristers in particular because they're all independent contractors. They're members of chambers, but essentially they're solo practitioners who are sharing offices, administrative staff. You know, the barristers are not even supposed to touch money, so you can't talk to them about anything. You'd have to talk to their clerks. But what ends up happening is you're now talking, you know, I've got an arbitration right now where my barrister, the other side's barrister, and one of the arbitrators are all from the same chambers. I couldn't even imagine that in the US, and it's not a conflict. The idea is, you know, they still have lunch together every day. They talk, but they just don't talk about the case. Is it a conflict? I'm not sure it is a conflict because while you understand the role, you understand your role in that situation. And I'll give you another example. At these conferences, I see folks that are arbitrators in some of my cases, and we say hello and, you know, talk about the weather, but we don't talk about the case. Is that a problem seeing someone socially? I think it's such a small group that does this that it's impossible not to meet other folks. So the issue of conflicts becomes, and maybe I'm muddying the water a little bit, but conflicts are situational, right? Is it a conflict under the English system to have barristers from the same chambers? No. Is it a conflict for an arbitrator to act as a mock arbitrator and then act as a neutral later? I think that's a far more interesting question.
That is the one that they get tied up in knots over, correct?
Right.
Yeah.
And the issue, and I'd like Alberto to touch on this, but I think the problem is when you've got someone acting as a mock arbitrator, you've hired this person to give you legal advice. You asked them, I'm taking a little bit of what a discussion Alberto and I had, but you've asked them to listen to your case, and you're asking them to help you win. What works? What sticks? What doesn't work? Which argument did you buy? What argument did you not buy? How do we make this better? That person is now employed giving legal advice to the client, and I think maybe conflicted out of acting as a, obviously, arbitrator in that case, but may get conflicted out of future events. I think that's something for you to touch on.
Or at least creates a disclosure obligation for
Yes.
future appointments that they've had acted for, you know, or either they have a conflict or they have acted for one of the parties in some capacity. You know, the way we hire mock arbitrators is usually, you know, via an engagement letter, just as we would hire any other firm, and we do think that it creates an attorney-client relationship. We want to maintain privilege, and we think that the whole mock exercise is privilege, and we tend to, and we would expect that in the future that arbitrator would be, at least will be required to make a disclosure about not the specific engagement, because we wouldn't want the arbitrator to disclose that they participated in a mock for us, but rather that they acted for us in some capacity.
Well, and I think that's very important. The language that you use when you're disclosing these conflicts or potential conflicts is very tricky because for that very reason, you mustn't disclose that you participated in a mock.
Right.
You know, I get hired to do mock trials for a lot of people because I was a trial judge for a long time. And you have to disclose all that, but you have to be very careful because you do have an engagement letter and you do have an attorney-client relationship. So you have to be very careful in the way you word that, but you must disclose it. I'm kind of hyper vigilant about the disclosure obligations, as I'm sure everybody here is, but I think the wording of that's tricky at best.
Judge
How
Reyes?
far do the disclosures have to go?
Well, as I say, I'm hyper vigilant about it. And the reason why, and I think we all are, is because we're terrified. There's only a couple of ways you're going to overturn our decisions in arbitrations, and one of them is failure to disclose. And, you know, it's getting, I don't know if you guys agree with this or not, but it's getting a bit more sophisticated. I just had a case yesterday where our chair was taken off the panel by another organization because she attended a law firm's Christmas party with one of the counsel, not with them, but at the same party. And I don't know how you guys do it, but in Houston, we have big parties. So, you know, I was scratching my head, and she disclosed when this lawyer came onto the case. She said, well, I was at a Christmas party, and he was at the same party, and we said hello and shook hands. And to your point, Sasha, I thought, well, that's a big nothing burger. And they took her off the panel, which is awful.
How does that factor into your decision whether to participate in these mock panels?
I thought you were going to ask participate in the parties. I go to parties. You know, I'm just really very vigilant. I just do not want to be that person that the case got written up and you guys go to conference and you talk about. I don't want to be that person. So I'm a little nutty about it, and I just disclose everything, which in my position is kind of weird. It's my 43rd year practicing law in Houston, Texas, and I know pretty much everybody in Houston, Texas. And so I have the general disclaimer at the bottom. You know, I said to Sasha, I said, I know you. Yeah, I appeared in your court 20 years ago. Okay. Well, so I have the disclaimer at the bottom, you know, that I can't remember and don't know and don't have the records to go back, you know, 23 years of court litigation to figure that out. But with that aside, I really spend time and a fair amount of money with an administrative staff making sure that I have accurately and fairly disclosed, you know, everything that I can think of that might be of interest to either of the parties.
Don, did you have a follow-up question?
No, I didn't. I was really curious about disclosure, though, and what you do, so.
Oh, how I do it, you mean?
Yeah.
Oh, well, we actually, in my arbitration little world, we created our own, well, I have this kid, he's sitting over there, and he is an engineer with Amazon. And so I went to him and I said, I need a really robust algorithm. I need you to write this for me. There's a really robust algorithm that helps me discern any conflict with any person ever, you know, write this for me. And if you don't have a kid like that, I'll give you his name and phone number. He will not help you, but anyway, he wrote an algorithm for me. We've created our own disclosure base, and we just keep piling in as much information as we can possibly get in there. And it's pretty cool because you put in a name, or you put in a firm, or you put in, you know, ConocoPhillips or whatever, and it just clicks out, you know, everything you've ever done with any of those people ever. And so it's just a matter of feeding the database.
I guess this would be a good time to ask if the audience has any questions based on what we've discussed thus far.
I have one, Allison.
Sure.
So, Don, I read your book. It was fabulous. One of the questions I had was, though, when you pick mock juries, you have a vast amount of information about the jury pool that the real jury is likely to be pulled from. And my sense is with picking mock arbitrators, you probably don't have the same amount of data. So how do you solve that problem?
You know,
You're
that,
trying to match arbitrators.
yeah, that is a problem, but there's a more significant problem, and that is sample size. When we do jury research, as an example, those are always inferential studies. What you're doing is from a sample, you want to infer characteristics to a larger population, okay? So that you can decide, here are the profiles of people who are going to be antagonistic to your client for these kinds of reasons. And you can discern them in the courtroom with their voir dire, et cetera, et cetera. So you have large sample sizes you can work with. That's not the case with arbitration. And you raise exactly the right question. You're dealing with very small sample sizes, and what kind of confidence can you have when you have 3 arbitrators, mock arbitrators, and you're trying to project what an actual panel is likely to do? So that's why I said initially at the outset, you have to be very, very cautious. And you have to decide, how can I select arbitrators that get as close as possible? And what kinds of questions can I ask to increase the probabilities that I'm getting valid and reliable answers from this group that are going to really be helpful in the actual arbitration. What we're experimenting with is an interesting concept of arbitration panels. Rather than looking at single arbitrators, we're looking at arbitration panels of multiple arbitrators. That gives us greater flexibility with the kind of research we can do. So that's one of the things that we're doing.
Don, in the beginning, you talked about validity and reliability. How well do the mock arbitrations match real arbitration conditions, and is that even the particular goal necessarily?
Well, you know, as I said, if the goal is to give your witnesses an opportunity to testify and they haven't before, if your goal is to let your senior executives know that their bad memos are really bad documents that are going to hurt them, if your goal is to make sure that your counsel is really prepared, they're doing it really well at ConocoPhillips. I'm very impressed with that. But I think that you have to understand, again, what are you trying to do? And I'm always very nervous when people want predictability. It's a slippery slope and a dangerous one.
How much of the success of a mock arbitration relates to being able to tailor your arguments to the particular arbitrator, recognizing that they're human beings and not yet chatbots, with personal perspectives? How much of the mock arbitration is aimed at tailoring a message to the particular decision maker?
Well, we have an expert right here in Sasha that if it depends on whom your arbitration panel is. If they're British, you're going to present a case very, very differently than if they're American lawyers.
You know, what's interesting about that is it depends on how the panel is composed, because it's a very different panel if it's all English barristers versus Australian, American, British. There's a different dynamic because you get the benefit of the experience and the procedural aspects of the cases they've heard in the US, Australia, England, wherever. But the way you present the case to an all-English panel is very, very different than if you've got a mix of different nationalities. So I think that's very useful.
You know, and what makes it even more intriguing is when you have a panel in which you have someone who's been trained and spent their entire legal life in London or with British law, someone from the French system, as an example, and then someone, an arbitrator from Asia, as an example, who has a very, very different perspective on what is truthful, how do you present evidence, what is believable, and how they interpret information. It's very, very different with those nationalities.
And do you find, as a result of your mock arbitrations, that sometimes alterations can be made within the team, within the legal team? Alberto, maybe you have experience with what types of characteristics would be most well matched to the decision makers?
Yeah, you can adjust the team to account for that, but at the end of the day, you need to present a persuasive case, no matter who your audience is, what nationality. So I think we focus more on presenting a persuasive case than making adjustments to account for nationality. Yeah, there may be some variation perhaps in the team, but I don't think that's as significant as you know, I wouldn't depart from my first goal, which is to present a persuasive case.
When we talk about persuasion, there are two attributes of persuasion. How do you persuade another human being to take some course of action or to change some course of action or make a very different decision? There are two key elements to persuasion. One is credibility, the credibility of the presenter, and the second one is the likability. Those are the two key factors. Now, under credibility, we look at expertise. Does a person know what they're talking about, or should they know what they're talking about? And that goes to competence and also to trustworthiness. Now, when you have someone who has been raised in the French system, as an example, or maybe in Tokyo, you might look at expertise and you might look at competence very, very differently than you would in the United States or the UK. The other is likability. why do we like other human beings? Well, there are two specific reasons. One, that either they provide what is called positive affect, that is, they give us positive feelings about them, or there's something called collinearity. They're like me. We tend to like people who are like us. We tend to trust people who are like us. And that's one of the real reasons for thinking about diversity and inclusion. We tend to like people whom we think view the world the way we do and have lived in the world that we have lived in. So those are things one needs to take into consideration also when selecting mock arbitrators, is what are the components of persuasion? Okay?
You know, can I throw in a little story? Do
Yes,
we have time?
absolutely.
Okay, so I was on a panel, and the subject matter had to do with some energy issues that had happened in the Middle East. And so a lot of the witnesses and the testimonial came from people who'd come over from the Middle East. And it was interesting to me because my husband and I have spent quite a bit of time in the Middle East, and we're very comfortable there. We like that. But the other two arbitrators had not. And they really struggled with kind of some of the things you're talking about, Don. They didn't relate well to the witnesses. They didn't understand them well. There was I'm not going to say it was a bias. I don't really think it was a bias, but it was whatever that fancy word was you just used, that they're not like me, And so they questioned a lot of their truthfulness, whereas I did not. I did not question it. We had completely different experiences on how we were receiving that information. And that was an interesting panel.
There's a little, in this little book that I wrote, it was fun for me because in addition to the theoretical psychological stuff I talk about, I have about 25 or 30 arbitrators from around the world who've contributed little anecdotes on each one of those sections. And there is one story from an American lawyer who presented a case in an international arbitration, and she said after the fact, and she talks about it in her anecdote in the book, they just didn't like my witness. They just didn't like him. Notwithstanding the fact that he was absolutely truthful, absolutely qualified, was a phenomenal witness in every respect except one. They didn't like him. And they lost the arbitration as a result of it.
I think we had a question on this side of the room. Yes.
I would suggest the subject matter also plays a pretty significant role. Insurance recovery work, and subject matter really matters because you have two sides. Not a normal dispute. You have arbitrators and you have litigants that set up on both sides. Although the English side, the English can play both roles in America, we can't. Either on the policyholder side or on the insurance company side. When I put together one mock for a major energy company on a major energy issue, I actually brought in a good friend of mine who represents insurance companies. I represent policyholders. So our panel really represented a mixed panel. And he was somebody that we could trust because we kept it confidential and everything, and we were running up on time, so we had to get answers pretty quickly. And that really did change the dynamic. We were hearing it both from my perspective as a policyholder arbitrator and also hearing it from a very well-respected somebody from the other side. Made a big difference. And we were making suggestions in real time, not just waiting till the end, giving a decision. We were actually making real-time adjustments to the presentation. So when it was all over, we had already managed to make significant changes in the way the arbitration was ultimately going to be presented to the ultimate panel. And then the last point was, because of the nature of the beast for insurance coverage, I actually knew the panel members very, very well. So I could project what was going to have an impact on them as well, because I knew them very well. So I think insurance coverage does have a bit of a different dynamic, but I would lengthen it out to subject matter does matter in doing the mocks and doing the thinking of how you're going to.
Yep. Absolutely. So the big clock is telling us we're nearly out of time. One more, is there, there's one more question, is that okay? Right here on this, yeah.
Homer LaRue from Howard University. Going back to the credibility question again, I wonder if the panel could talk about whether or not, when they talk about credibility, they're talking about using demeanor evidence, body language, that sort of thing, the likability, I guess, or are you talking about whether the witness's testimony is consistent or inconsistent with facts that are fairly well known or accepted in the record? Which do you use? And I think the empirical evidence is going one way, but advocates are not necessarily going in that direction.
Oh, I'm just going to say, you can like somebody all day long, but if you don't believe them, you know, likability won't trump. And I don't know, do you agree?
I absolutely agree.
Likability doesn't trump, you know, the facts. You
But
guys?
in my experience, the opposite also happens, which is you've got a very truthful witness who's sticking to the facts, is consistent with it, but the way they're presenting the evidence really turns off the arbitrator. They're looking down. And I'll give you a great example. We had a witness that was an engineer, and that's how he thought. So if you ask him the question, is the sky blue? He would say, well, you know, in space, there's really no color. But as you get closer to the atmosphere, there's particles, and they reflect, and it's a 20-minute answer for it, the sky's blue. Arbitrators hated it, absolutely hated it.
Thank you. I think our time is up. Thank you.